Good morning to all of you. Andariki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukara. Professional Ethics class. Friends, previously I told you Madras High Court judgment wherein a person against whom a lawyer, wherein a lawyer against whom contempt proceedings are issued, it is better for him not to appear before the same court. ఏ కోర్టులో అయితే అతని మీద కంటెంప్ట్ పడిందో కంటెంప్ట్ హైకోర్టు చేస్తుంది, బట్ ఆ జడ్జి గారి ముందు వెళ్ళకూడదని మెడ్రాస్ హైకోర్టు జడ్జిమెంట్ ఇచ్చింది. రీజన్ ఈజ్ బికాజ్ మీ ముఖం ఆయన చూసి ఆయన ముఖం చూసి ఆ ఇల్ ఫీలింగ్స్ ఉంటాయి. అలాగే a topic has come whether the chamber can be allotted by the court to the lawyer who has been convicted in a contempt of the court case. ఇనిషియేట్ అయ్యి శిక్ష పడి ఉంటే వాళ్ళకి చేంబర్ అలాట్మెంట్ ఉంటుందా లేదా? ఈజ్ ఇట్ యాజ్ పర్ Advocates Act or as per the rules made by the Bar Council or not అని ధర్మ సందేహం వచ్చింది. The matter came up to the level of Supreme Court. Supreme Court said, we don't want to interfere. In the orders of the Allhabad High Court. Allhabad High Court ఏం చేసింది? Yes, they said the lawyer, the advocate is not competent to get the chamber because, please remember, allocation of a chamber or allotment of chamber is only a facility, but you can't claim it as a right. ఇది తెలుసుకుంటే ఈజీ. సో ఈ డీటెయిల్స్ మొత్తంకి వెళ్దాం. In the CJI, Chief Justice of India, Honorable Justice B.R. Gawai and Augustine George Mashi, in the case of Chandra Pandey, his advocate. Chandra Pandey versus High Court of Judicature in Allhabad and others. SLP number 17588 by 2024. So, the Supreme Court bench on 21st May, that is yesterday, 2025, refused to interfere with the orders of or with the decision of Allhabad High Court. What decision Allhabad High Court made? Allhabad High Court decided or held that advocate convicted in a contempt case is not eligible for the allotment of a chamber under the High Court guidelines. Already I told you, allotment of chamber is not a right, but is only a facility. As regards Chandra Pandey, the allegation is that he has revolted and he has passed disparaging comments, adverse comments or bullying comments against the Chief Justice of Allhabad High Court and 9 other judges. It was taken as a contempt. There is no remorse on him. He did not say sorry. But whatever it is, we don't know what happened. But anyway, he was convicted according to Section 12 of the Contempt of the Courts Act. You know, Section 12 of the Contempt of the Courts Act says that the punishment should not be more than 6 months and the fine should not exceed 2,000. ఇది మీ అందరికీ తెలిసిందే. నౌ ద పాయింట్ హ్యాస్ కమ్. ఇన్ లక్నో న్యూ బిల్డింగ్ ఆఫ్ ద హై కోర్ట్స్ ఆర్ అండర్ కన్స్ట్రక్షన్. ఈ న్యూ బిల్డింగ్కి అటాచ్డ్గా లాయర్స్ చేంబర్స్, సీనియర్ అడ్వకేట్స్ చేంబర్స్ అలాట్మెంట్ చేయడానికి దెర్ ఇస్ అ ప్రపోజల్. హైకోర్ట్ హ్యాస్ ఆల్సో గివెన్ క్లియరెన్స్. యాక్చువల్గా ద లిస్ట్ వాజ్ పబ్లిష్డ్ ఇన్ ది 4/7/2023. ఎవరెవరికి ఇస్తామో లేదని దాంట్లో ఇచ్చారు. దాంట్లో చంద్రభూషణ్ పాండే, his name is rejected. Of course, when the Bar Association or Bar Council was contacted, High Court said that already the 500 people are in the waiting list, we can't accommodate him and another. But this Chandrabhushan Pandey, he filed a writ petition, writ of mandamus, before the Supreme Court, stating that Allhabad High Court was not logical and correct in refusing him the chambers. He is a man. He says that he has conducted more than 1,600 cases in Allhabad High Court. People or litigants are coming to meet him. Therefore, there is every necessity for him to be allotted a chamber because as senior, he has got number of He has got good practice. That's what his contention. But High Court said, the registrar said, so there are certain guidelines, particularly guideline that is clause number 4. It says, please remember, clause number 4 says, an advocate against whom contempt proceedings are initiated and culminated into conviction shall not be eligible for allotment of a chamber. Then the petitioner, that is advocate Chandra Pandey, he contested the same by filing writ petition under Article 226 of the Constitution of India. He says that clause 4 is not legal and logical because it's a new building which is being constructed in Lucknow. So the reject list is by the registrar is not legal. And as regards this, Allhabad High Court already dismissed the petition, saying that this is very important. Allhabad High Court find out a law point that he is estopped. Res judicata estopped. Promissory estoppel. Estoppel and enti. When you promise to do something, you have to do it. He himself said that, disclosed that he was convicted. Conviction that is that he was stopped from challenging the guidelines. Number 2, there is heavy delay in approaching the even High Court also, because list was published on 4/7/2023 and he filed the writ petition in the year 2024. There was a delay of 16 months. Heavy delay can't be accepted. No Limitation Act. Third point. The case will definitely, his case, particularly Chandra Pandey's case, will fall under Rule 4 or Clause 4. Chamber can't be claimed as a right. Bench was also informed by the High Court there are no vacant chambers. Already 500 members are on the waiting list. Right? In this connection, CJI, Justice B.R. Gawai sir, asked him, why do you require a chamber? You can have an outdoor chamber. You have got good practice. Chandra Pandey said, Milord, I appear nearly in 1600 cases and the litigants they will be coming. So, even for their sake, I need a chamber. Supreme Court said, no, we don't want to interfere because you people, you do the acts of contempt of the court. You don't apologize. You are getting convicted. Now you want a chamber. For what? For once again making contemptuous remarks against judges and but they said, number 1, there is no vacancy according to High Court. Number 2, Rule 4, it comes as a friction. So since you are convicted, normal if any officer, government officer is kept in custody, police custody for more than 48 hours, if he is detained in legal judicial custody, yes, definitely he will be suspended first. If he is convicted, definitely he will be removed from the service. So, alaga Advocates Act kuda purpose ade. You all know the purpose of the Advocates Act is, in my view, to protect rights, interests of the advocates, at the same time to take out or to prevent the activities of the black sheep who do the so-called professional or other misconduct. Sorry, we have diverged from Contempt of the Courts Act to Advocate Act. So contempt, civil contempt or civil criminal contempt. So here he has committed criminal contempt by disrupting the proceedings of the court by commenting, by making disparaging comments against the judges. Not one, against the Chief Justice of the High Court and also 9 judges, which is unpardonable in view of the judge, in view of the judiciary. So allotment, they don't want to interfere. Now we can't get any chambers. Right? With this, I am stopping here. Thank you very much.